Good morning. My name is Richard Thorpe. I am the chair of Panel B, and we are calling the Panel B meeting of the February 12th Medical Board of California meeting to order at this point. Before I call the roll, I would just like to acknowledge that, we have a number of cases before us today that are extremely consequential. And just to say that, there are people's careers on the line, there are licenses on the line, there are people who have passed away not in this case, but that we're going to try right now, but later. And this morning, I was overwhelmed with the severity and the solemnity of the work that we're doing. And also, justice is also, the scales of justice are justice and mercy. And so I would just like to remind the panel this morning of that. And before we start, I feel like I just need to ask God for a moment of blessing to just help us with these decisions today. So if you don't mind, I'm going to just ask for a prayer for this morning. Father, thank you for this day. We ask for your wisdom and your mercy and your grace. In your precious name, amen. Okay, with that, Judge, we can... Oh, I think we need to call the roll. Yeah. So, great. All right.
All right, Dr. Ayla Rodriguez. Ms. Chung. Ms. Lawson.
Here.
Dr. Mahmood. Dr. Thorpe.
Here.
Dr. Yip.
Here.
Ms. Remke.
Here.
All right, we have a quorum.
And now, Judge Van Rooyen, if you'd like to proceed.
Thank you very much, Mr. President. All right, we have everyone here. Court reporter, are you ready for us to go on the record?
Yes, I am. Would a couple of doctors, I didn't hear their roll call. I just want to make sure the mics work on Dr. or Ms. Chung. Do you mind saying something?
Sorry, Annie Chung, I'm here.
That works. And then two people to your right. Let's see. It's probably all fine. But yes, I'm ready to go on the record. I'll let you know if I don't hear something.
Just let us know if you can't hear anyone and we'll address it.
I appreciate it. Thank you.
Thank you so much. All right, we can go on the record. All right, we are on the record before the Medical Board of California, Panel B, Department of Consumer Affairs, State of California. We're here in the matter of the statement of issues against Sean James Siburn, spelled Sean, S-E-A-N, James, J-A-M-E-S, Siburn, S-I-B-U-R-N, M-D. This is Medical Board of California, case number 800-2024-105866, and the OAH case number is 2025-010-414. That's the number set for the oral argument. Today is February 12th, 2025. It's 9:09 a.m. Matter was noticed for hearing at 9 a.m. This is the date and time set for the oral argument in the notice of hearing for oral argument after non-adoption of a proposed decision. We are conducting the oral argument in person and by WebEx video conference. My name is Wim Van Rooyen, spelled W-I-M space V-A-N space R-O-O-Y-E-N. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over the oral argument. We have taken a roll of the panel, and we do have a quorum of the panel present to hear the oral argument today. And let me now have appearances of counsel, please, starting with the Attorney General.
Morning, Your Honor, Deputy Attorney General.
I'm sorry, didn't hear that.
Sorry about that. Good morning, Your Honor. Ladies and gentlemen of the board, Deputy Attorney General Joe McKenna on behalf of complainant.
Good morning to you, sir, and on behalf of the physician.
Morning, I'm Jeff Lewis here representing Dr. Sean Siburn.
Good morning, Mr. Lewis. Good morning, Dr. Siburn. Thank you very much for being here. And can our court reporter please state your name and court reporter certification number?
Yes, Your Honor. Your certified court reporter today is Nick Milana, and my CSR number is 13912.
Thank you very much. Appreciate that. So for the oral argument, the following process and time limitations will apply. These were previously provided, but I'll summarize them. First, the respondent will have 15 minutes to provide an opening argument, after which the Attorney General will have 15 minutes for his opening argument. After that, the respondent will have 5 minutes for a closing argument, and the Attorney General will have 5 minutes for his closing argument. These time limits will be strictly enforced. I will be keeping time. However, that is a courtesy only. I expect you all to keep track of your own time. I'll try and give you a courtesy warning when there's 1 minute left. The argument shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. Either I or any panel member may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral argument by counsel, I will offer the respondent physician an opportunity to address the panel. If the respondent elects to address the panel, I will place the respondent under oath. As we already mentioned, there's a court reporter present to record the proceedings, so please make sure to turn on your microphone and speak loudly, clearly, and slowly for the benefit of the court reporter. After oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will be receiving it in the mail sometime in the future. Again, please remember that all arguments must be based on the existing record and no new evidence will be heard. And as a reminder, the board has already had the benefit of reading any briefs that you submitted. With that said, does any other matters to discuss before we proceed to argument from the Attorney General?
No, Your Honor.
From the respondent?
No.
Thank you very much. Then we will start the oral argument. First, the respondent, and your time starts now.
Okay, thank you. As I said, my name is Jeff Lewis. I represent Dr. Sean Siburn. The main point I want to make today is that statements, whether they are false or not, are not any more connected to the practice of medicine than the conduct about which they relate. Here, this is about denying him a license for allegedly making false statements about conduct that was already determined to be unconnected to the practice of medicine and as a matter of law is not connected to the practice of medicine. So how did we get here? In March of 2022, yes, almost 3 years ago, Sean Siburn applied to transition from a postgraduate training license to a full medical license. He had been in residency for almost 3 years, and most of it during the COVID pandemic. A few months before he had applied, the board had received a complaint. It interviewed him that following summer and eventually filed an accusation against him in November of 2022. It had to do with allegations that he had, without consent, recorded an encounter with a consensual sexual partner. At the hearing, he denied the allegations, and the administrative law judge did not believe him and recommended that he be put on probation. This board non-adopted that proposed decision and ultimately determined correctly that the allegations were not even a valid basis to discipline him because they were not connected to the practice of medicine. It had to do with private, non-criminal sexual behavior, which has been held for decades, is not connected to really any profession, in this case, medicine. Despite that, he finally received an answer on his application almost a year ago in March of 2024, saying that he is not entitled to a license because he lied at this hearing. At the hearing like this one before the board members, Sean said that he, in fact, did do what he was accused of doing. Despite hearing this, and even with the authority to open up the record, amend the accusation, take new evidence, and take that into evidence, the board members decided not to do that and stick with their legal obligation under the Constitution to dismiss the accusation because it does not have the jurisdiction to prosecute just any crime, only crimes under the Medical Practice Act. The alleged crime was not under the Medical Practice Act, so this board had no jurisdiction to prosecute that. He had not been prosecuted, so it rightly concluded that it had to dismiss the accusation. Despite that, he was denied a license because he allegedly lied about something, and that the complainant claims is substantially related to the practice of medicine. We have yet to hear any coherent explanation for how that is so. The thinking seems to be that because it was in a medical board hearing under oath about the matters that were ultimately at issue, the ultimate facts at issue, and pertain to matters that are potentially illegal or criminal, that they must be connected to the practice of medicine. But what this overlooks is that just because someone is put under oath and is testifying before a government body like the medical board, that does not mean that that what they're being asked to testify about is a legitimate thing for that government body to be probing into. That was indeed the case here. There's never any constitutional basis to be probing into his sexual life. The proposed decision, for instance, describes the fact that he was under oath and before the board members. Doesn't take much imagination to see how someone in those circumstances will be willing to say anything potentially, and the power that the government can have over an individual is so great that is why that the Constitution limits how much the government can probe into someone's private life. It is of constitutional importance that this board recognize that it simply does not have the authority to deny him a license for allegedly lying about something that it had no business asking him about in the first place. One of the causes for discipline alleged claims that he stood to benefit from his lies, his alleged lies, but again, we don't see how that is possible since the only benefit he could have had was to maintain his postgraduate training license without any restriction or probation. But the only basis that there was alleged to do that was an unconstitutional one. So he stood really only to not lose something he never should have lost in the first place. So the reason the acts about which he is alleged to have lied about are not connected to the practice of medicine are for two reasons. One, as the board said before, as a matter of constitutional law, has been held that it's not connected to the practice of medicine, and as a matter of what is called collateral estoppel. The Supreme Court United States Supreme Court, there's a nice quote from it from Ash v. Swenson. That's at 396 U.S. 436. The court stated, quote, "Collateral estoppel is an awkward phrase, but it stands for an extremely important principle in our adversary system of justice. It means simply that when an issue of ultimate fact has once been determined by a valid and final judgment, that issue cannot again be litigated between the same parties in any future lawsuit." As the Supreme Court explained, the California Supreme Court, the collateral estoppel is a distinct aspect of what's called res judicata. It involves using an issue in a prior case to that arises in a new cause of action. So, for instance, previously, the previous cause of action, you would say, was to discipline his postgraduate training license. The new cause of action now is to deny him a full license. The same issue, though, is ultimately what happened in his bedroom with this other person. Whether he lied about that ultimately turns on what happened that night. But and previously, in the previous accusation, the ultimate facts at issue were what happened that night. The administrative law judge decided to make findings about that, but this board explicitly decided not to make any factual findings because it was beyond its jurisdiction effectively. So the collateral estoppel effect of that is that the board determined validly and finally, when it made its decision and decided not to reconsider it and open up the record for new evidence, it decided that those ultimate facts have no basis to whether the truth of them, regardless of that, they are not a valid basis to discipline his postgraduate training license because it's not a base to that determination now is binding now as a matter of collateral estoppel, and the briefs discuss all the elements of that and the traditional public policies that are forwarded by that, such as not harassing him repeatedly, endlessly over the same issues, and so that he can move on with his life and trust that the judgment, as today, for instance, if he were to be given his license as he should be, that he can rest assured that he will not be, again, litigating this issue. The other reason it's the conduct underlying what he was alleged to have lied about is that it's still not connected to the practice of medicine as a matter of constitutional law. The decisions cited in the briefs and previously by this board, the McLaughlin decision and Morrison, make clear that private sexual conduct is not connected to the practice of medicine. And although the cases do not necessarily make this clear, it's implied and a basic constitutional rule of law that this board, as I said before, cannot prosecute just any crime. If a crime is to be a basis for discipline or denying a license, that is the role of the other aspects of government to prosecute those crimes. In this case now, the complainant is alleging that Dr. Siburn committed perjury in lying in the previous hearing. Again, just like before, this is not a crime that falls under the Medical Practice Act. He has not been charged with, prosecuted, convicted of perjury. And in this case, we can definitely say that that cannot happen because perjury requires that the statements be material. That means that it must have had some possibility of influencing the outcome of the proceedings. But as we just observed, and as this board observed, if that were the case, that would violate his constitutional rights and exceed the board's jurisdiction, does not have the authority to have the outcome of the proceedings influenced by what in fact happened the night that he was alleged to have secretly recorded the sexual encounter. Yes, sorry, I lost my train of thought. So he cannot be guilty of perjury because, like I said, had the outcome of the proceedings been influenced by his alleged false statements, it would be violation of this board's authority and his constitutional rights.
1 minute remaining.
Okay, thank you. Lastly, I would like to emphasize that the handling of this case was not proper. This is, like I said, it will be almost 3 years since he applied. The board typically takes 7 to 8 months to process an application. That 7 to 8 months would have occurred about when the accusation was filed in November of 2022. There's no reason why the licensure application could not have been consolidated with that hearing. Ultimately, he was denied a license for things that happened well over a year and a half after he originally applied. Clearly, they had any basis to deny him a license was not based on anything at the time the accusation was filed. So there was no reason to delay the determination. And again, if it were to be the same issue were to come up, it still raises questions as to why we're here today. Would he be asked to be seeking, if he were granted a license and then disciplined later for having lied about what he's accused of lying about now, whether that would make any sense? I doubt that would.
Thank
be
you,
the
counsel.
case.
Your time is up. Thank you. The Attorney General, you have 15 minutes, starting now.
Excuse me. The proposed decision denied applicant's application for a compelling reason. He intentionally lied under oath repeatedly in a disciplinary proceeding before this board. To be clear, the statement of issues hearing was not about the events which involved the surreptitious video recording made by the applicant. It's about whether an admitted perjurer should be granted to the license to practice medicine by the Medical Board of California. The facts are crystal clear. Applicant systematically lied under oath in the July 2023 administrative hearing. He told a long and detailed story, which made him appear to be the victim, and he painted the real victim in that case as an enraged, violent aggressor. Applicant callously attacked the victim's character during the hearing, and the victim was subjected to extensive cross-examination, which the applicant knew was filled with hurtful lies. Applicant's testimony was well prepared, methodical, and comprehensive. He had an answer for everything, but as we know, it was all a lie, because the applicant also said in his own words under oath to this board that it was in November 2023. Now, it's troubling to this day that we still hear in argument now, as well as in the briefings, it referred to as alleged dishonesty. He's already admitted to this board, I lied. I lied in July of 2023 when I swore to tell the truth and I took an oath, but still maintains the position that it's alleged dishonesty. It's not alleged. You know this. Complainant's written argument submitted for today's hearing contains a selected list of excerpts from the transcript of the July 2023 hearing. It includes more than 24 excerpts of the lies and misleading testimony applicant gave under oath. Applicant's lies re-victimize the victim to further his own interests in this case. And when later confronted at the statement of issues hearing with his own statements, he invoked the Fifth Amendment not to testify. And he did that more than 40 times. I don't know what kind of game applicant is playing with this board. It's bizarre that he invoked the Fifth Amendment during the statement of issues hearing, even though he previously admitted the truth to you. We know that he lied in the first disciplinary proceeding, and he also invoked the Fifth Amendment during his subject interview prior to the filing of the accusation in that case. He was also intentionally misleading with the board's investigator during the entire investigation. So What we have is an erratic pattern of lies and deception by this applicant over a period of more than 2 years, followed by a calculated and prepared surprise confession to this board. Applicant then demands a statement of issues hearing, but he refuses to provide any testimony or evidence at that hearing to explain the lies, offer evidence to show remorse, some level of contrition, to invite the board to provide mercy. He doesn't do that. He has no efforts demonstrated towards rehabilitation to show the board, and he has no positive character evidence, no character letters, no character testimony, does not have a therapist, spiritual advisor come in to discuss this major transgression in his moral character, what he did, what he admitted to. He didn't provide any of that, even though the burden is on him to do that. Now, applicant argues why he thinks he should get a license. And his arguments show that he still does not genuinely accept responsibility for the conduct alleged in the statement of issues. Where is the contrition? Where is the acceptance of responsibility? Applicant's principal argument is that his alleged dishonesty did not involve his medical practice. And because the alleged dishonesty is not connected to the practice of medicine, then his actions should be of no concern to this board, and he should get a license to practice medicine immediately. Again, to be clear, the statement of issues is not about the surreptitious video recording. It is about whether an admitted liar should be granted a license to practice medicine in this state. And I'll address the collateral estoppel argument towards the end of my comments, but please don't be snagged by that because it is not applicable to the case. However, what is clear in these circumstances, what the law says no. Decades of case law has established that licensed professionals are required to be honest. And that intentional dishonesty alone demonstrates a lack of moral character, which satisfies a finding of unfitness to practice medicine. Applicant misleads the board by arguing the so-called honesty rule is only limited to criminal cases or cases where the lies are directly about the practice of medicine. That is false. That is false. Case law states that honesty is a critical and necessary attribute for all professional licensees. In the case of physicians, one's character trait for honesty is a core qualification that it is absolutely related to the practice of medicine at all times. The statute at issue here, Business and Professions Code section 2234, subdivision E, says to evaluate whether the dishonesty, the lying, is substantially related to the qualifications, functions, or duties of a physician and surgeon. The legislature has directed this board to consider not just the actual practice of medicine, such as skills or knowledge, but it has established a much broader inquiry into an applicant's qualifications. For anyone to argue that honesty is not part of the qualifications to be licensed as a physician is absurd, offensive, and is in complete opposition to case law and the past actions of this board. Physicians have ethical duties to patients. They have ethical duties to their colleagues. They have ethical duties to their hospitals where they work. They also have an ethical duty to the community at large, to be honest in all dealings as a physician. Before the board can issue a license to this applicant, you have to ask yourself, what evidence did he submit at the statement of issues hearing that shows he does not present a threat to patients? The answer is nothing. Despite the serious allegations in the statement of issues, which he had plenty of time to prepare for, he presented no evidence at hearing, even though it is his burden. It is his burden when he demands a statement of issues hearing to show, to demonstrate, to prove that he is entitled to a license in this case. He is entitled to ask you, the medical board, I am fit to be a physician in the state of California. And he did none of that. He failed to respond to any of the allegations of dishonesty or unprofessional conduct in the statement of issues. His mea culpa before the board in November 2023 was mostly about his case and how it had adversely affected his life. He only gave a lukewarm apology about what he did to the victim. And because of constraints of time, I will not go into his statement, but it's available to the board. It is in the record, and I urge all board members to read. When the applicant had an opportunity to talk directly to you about his level of acceptance of responsibility, his contrition, do I deserve mercy? You'll see that it is all focused on the applicant. It's not genuine. In terms of appreciating the wrongfulness of lying under oath, applicant acknowledged nothing to this board about the lying. He failed to take that opportunity, which he had to inform you that he understood his duty was to be honest at the hearing. When he held his hand up and he took that oath, he understood the gravity and the solemnity of being honest before his own board, or what he had hoped to be. He failed to show any indication at all about how it's important to be honest in all situations as a physician, even if telling the truth may be to his own disadvantage. At no time has he shown
I'm sorry, the court reporter did not hear that.
I can pause.
Let's go off the record real quick, and I'm stopping your time.
Yes, Your Honor.
Apologize. That was an announcement here on site by the hospital. That was not part of the board meeting. So, you know, we had to work with those constraints. Mr. Court Reporter, we can now go back on the record.
Yes, Your Honor, I'm ready.
All right, we are back on the record. It is 9:39 a.m. We had an interruption by an on-site announcement here. I have stopped the time for you, Mr. Attorney General, so that you weren't deprived of any time. I apologize for the interruption, and you may now continue your argument. Thank you.
Thank you. At no time has the applicant shown that he appreciates how wrong it was to mislead and lie the members of this board while he was under oath at the prior proceeding. He didn't say anything about that. It was about me, me, me. Granting a license to this applicant would send a terrible message that not only is intentional and repeated dishonesty acceptable, but that it is okay with the medical board if physicians come before the board and flagrantly lie, even while under oath. The medical board's primary mandate is public protection. Granting a licensed applicant in this case would be both a betrayal to this mandate and to California medical consumers. Counsel for the applicant has suggested that his statements, his alleged dishonesty, could not be perjury because it wasn't material to what he testified about, because this board later determined that it was not connected to the practice of medicine. And we're not going to talk about whether it was or not. That's the board's decision. What the applicant is not in the position to decide at the time he raises his hand and he takes that oath is whether or not what I'm testifying about will at some point be decided not to be connected to the practice of medicine. This board may not decide it's substantially related to the duties of a physician or surgeon. No person taking that oath can ever be in that position. They have to understand, appreciate, and accept to tell the truth. And there is no question that his lies, his deceptions, his painting the picture of the victim the way he did was material to concealing the underlying conduct, which was the videotaping of the individual. Again, that's beside the point. He lied. That in and of itself is significant. As I've already discussed, there is no replacement for honesty. That is a core qualification for a physician. Please don't get hooked by that. The fact that he did not get tried for perjury, that's beside the point. He lied under oath, and it was material to the facts that he was testifying about. So there is no question he committed perjury. Secondly, the collateral estoppel argument, I won't go into very much because I'm certain that the board has both the accusation and the statement issues side by side. And in order for it to be collateral estoppel, the issue in the statement of issues has to be identical to the prior issue tried in the accusation matter. That is the first prong to establishing collateral estoppel. And I think, as I've made clear at this point, we did not retry that case. The statement of issues is not about that case. It is about the lying, the absolute disrespect for the oath that he took. It is not collaterally estopped. This board is not collaterally estopped. It is not violating the Constitution by considering the allegations in the statement of issues. That is just simply false. And to the extent counsel suggests a little bit further down the line that this is private sexual conduct and the board is overreaching by coming in and making determinations about how people live their lives privately, that is not at all what took place in this case. This is not some sort of star chamber investigation proceeding while the medical record grabbed the applicant, hauled him into court, shined a light in his face and said, answer these questions. This was a duly initiated investigation brought to the medical board's attention by the victim, alleging clearly what is a criminal act to videotape somebody without their consent. So the board dutifully initiated an investigation. They had to do that. And they brought the investigation. He misled during the investigation. He took the Fifth Amendment. Anyone wants to complain about the investigation not moving along as fast as it could have, he needs to accept responsibility for that. But again, that's been a problem for this applicant, is accepting responsibility. So the issue should not at all concern the board that the applicant here was pulled in off the street and somehow subjected, and that the board used its powers to force him into a position he otherwise should not be in. That is not the case. And the ALJ made a correct finding, and the board did what it did. And just quickly sum up, the proposed decision should be adopted. An applicant's request for a medical license should be denied. Thank you.
Thank you very much. All right, now the respondent has 5 minutes for a closing argument, and that starts now.
Thank you. So I did not hear any reason that said why the alleged lies Dr. Siburn allegedly committed are a valid basis to deny him a license. Again, it seems that the emphasis is that he lied in a medical board hearing. That alone cannot justify denying him a license because it fails to establish that there was a valid basis to raise those factual issues in the first place. Whether or not it was done in good faith or not, or by the book in all other respects, for the most part, that the central factual issues were not connected to the practice of medicine cannot be used to justify denying a license later, because that would simply negate the protections that the Constitution are supposed to provide from the board probing into that sort of thing in the first place. Would like to maybe clarify that the two issues that are identical here are the factual issues of whether he is telling the truth now or whether he told the truth at the hearing depends on what in fact happened about what he was speaking about. Whether he lied about it necessarily requires determining what in fact happened that he was talking about. That is different than saying whether he should be given a license as an admitted liar. that is a legal issue. Granting a license is a legal issue. So of course it is different than the factual issue. That's comparing apples and oranges. The same issues are whether the facts are the same issues, whether the surreptitious recording happened or not. If it didn't happen, his denial was the truth and his admission was the lie. If it did happen, his denial was the lie and his admission was the truth. The other thing is that the complainant seems to be focused on how a contradiction in the record doesn't require making some factual finding about the conduct, but it certainly does for the reason I just said, that it affects whether the denial or the admission was a lie. And we've already discussed why that can't be done. It's not within the board's jurisdiction. Lastly, nobody denies that honesty is important in a physician's fitness. What is crucial, though, is that we're not disputing that honesty is important. It's how you determine someone is honest. Surely not any lie is going to be relevant. Someone lying to their spouse, as the board's example, to use the board's example, extramarital affairs could be very easy for someone to be put in a very difficult situation to choose between their marriage, private sex life, and their medical license. Obviously, things that happened 20 years ago are not relevant because there's a 7-year statute of limitations. Clearly, what they are alleged to have lied about is of paramount importance. Here, there's no reason why what he was speaking about is connected to the practice of medicine. Just because he was asked about it in a board proceeding doesn't make it any more connected, because it does not establish that the board had any valid basis to ask him about it in the first place.
1 minute remaining.
Lastly, I'd like to emphasize that in the case that was cited in the statement to the board, Ohio v. Reiner, 532 U.S. 17, that case, the Supreme Court emphasized that the Fifth Amendment also serves to protect those who are innocent. Those who take the Fifth Amendment are not necessarily doing it to protect them as a guilty person, but it is also to protect them from getting caught up in, I think it uses some language like from a sticky situation of being prosecuted. It's the same sort of thing. We're using it now. The complainant is alleging that he's committed a crime. Any further testimony about that or speaking about that could only present a danger to him of getting caught up in a prosecution about perjury, which we want to avoid and move on from. There's no reason to deny him a license, so we respectfully request that this board grant him a license. Thank you.
Thank you, sir. And now the Attorney General has 5 minutes as well. Thank you. It starts now.
Yeah, listening to defense closing, it's difficult to understand, and it's circular, and I think it suffers from being tone deaf about the issue that complainant wanted applicant to focus on. That's what the statement of issues was about. Show us your rehabilitation. Show us your remorse for your conduct. If you believe mercy should be preceded by an act of contrition, acceptance of responsibility, so that you know you're not handing over a license to somebody who's just blowing smoke and will say anything, then you need to see proof. What I just heard, this is how the defense characterizes the lying that took place at the underlying proceeding. A contradiction in the record. Those are the words, a contradiction in the record. It's that sort of view from 20,000 feet about honesty and wanting to characterize it as something that, you know, it's among a set of attributes, but it's not the most important or near the top of the list. That is outrageous. It's absurd. You can't conflate it with lying to a spouse or extramarital affairs or somebody's favorite color, as was used during the statement of issues hearing. This is why he was called to testify at that hearing, to testify as to those matters. He was sworn in. He was asked to be honest so that this board could receive a full and robust record and perhaps would have made the same decision that it made anyway. But at least you had truthful, honest evidence, because at the end of the day, as you all know, you are here to protect the public. And you want the fullest, most robust record you can to make the decision. It is not up to physicians or applicants to decide what you're going to hear. Again, I don't think we've heard anything that suggests the applicant has taken responsibility for his conduct. So I'll restate the complainant's position that the proposed decision should be adopted, and his application should be submitted. Thank you.
Thank you very much, sir. All right, would your client like an opportunity to address the board?
No, we'll pass on that.
All right, thank you. I'm still going to see if, is your client willing to answer questions from the board?
If it pertains to matters that will incriminate him, I will instruct him to invoke the fifth. I can think of some legitimate questions, so if they want to ask that, they're welcome to.
Sure. So I'm going to administer the oath for you. If you can raise your right hand, please. Do you solemnly state under penalty of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? Thank you very much, sir. Let me see. I'll start from the left there. Ms. Chung, do you have any questions for the respondent?
No, not right now, Judge. Thanks.
Thank you very much. And then Ms. Remke, do you have any questions?
Not at this time.
Thank you. Dr. Yip?
No, thank you.
Dr. Thorpe?
Yeah, I do have a question. I'm not sure that you can answer it though. Because honesty is truly a core value for being a physician. It is every single day, every patient you see, every encounter you have, every procedure you do depends on truthfulness. It doesn't matter to me. I mean, this argument, this legal argument, I'm sorry, I kind of got lost in it. It's too involved for my poor brain. But I do know this, regardless of, so what I would like to see, you're a young man. You have put work in to try to do something right in your life. And I appreciate that. So part of this is a statement, of course, that's what I'm doing right now, but I also have my question is, I want to do something that would not just, destroy your life. But I have not seen any evidence of contrition. I've not seen any evidence you did say that you lied the first time, that is true. But since then, we have no evidence that you are from now on going to be truthful, because that is really the issue. So that's my question is, in spite of wanting to do something, we don't have any evidence that we can, as a board, move forward with granting a license for you. And so I would like to hear something from you that gives me a toehold, at least, of a sense that you do recognize how important honesty is.
Let me say something, then he can add on to that. So it's not his duty to prove, the statute says he doesn't have to prove he has good character. Like I said, honesty is no doubt a core value, like you said, in practicing medicine. When his license is denied, he can request a hearing and a statement of issues is produced. And the statement of issues is supposed to say the regulations and statutes that he needs to demonstrate compliance with to get a license. It alleged that he is not in compliance with Section 475 of the Business and Professions Code, and other sections, all about having allegedly lied at the previous hearing. He does not need to show that he is rehabilitated from that if it is not a valid basis to assess his fitness for practicing medicine. Like I said, honesty is no doubt important. What the crucial distinction is what acts of dishonesty are a valid basis to judge someone's fitness. We could, the point is that if he's lying about just anything at a medical board hearing, like, are we going to say that we're concerned about patient safety because he lied about whether he has a membership at a gym or whether he ate vegetables the night before? You know, how trivial can we get before we see that it's not just any act that matters? And it's tempting to look at a board proceeding and think that it's important that they tell the truth, and that is true, but we cannot forget that the board has to exercise its authority correctly and properly. If it raises questions that are not something that it should be delving into, it can't hold that against someone for not telling the truth.
Counsel, I appreciate I'm liberally giving you more opportunity to argue, but this is becoming a second session of argument. Are you going to allow your client to answer the question?
Yeah, I was just about to.
Thank you very much. Let's
Yes.
turn the microphone to him.
Dr. Thorpe, I strongly recommend you not only read the transcript from the last hearing, but also watch the video. I'm going to leave it as from that as well.
Thank you. Any other questions, Dr. Thorpe?
That's all.
Thank you. Ms. Lawson, do you have any questions?
I guess I don't have any questions. Thanks.
All right. Any other board members have any additional questions? I don't see any hands up. Thank you very much. That concludes the hearing in this petition. The record is closed. Case is submitted for decision, and we are off the record in this matter. The panel will be deliberating in closed session. Thank you.
Until the public attendees will be now taking the meeting into closed session. Due to timing issues, there won't be time to re-adjourn to get together again just to adjourn. So we will be ending the session now. Thank you very much. The panel A meeting will start at 2:00 p.m. Thank you.